Rallies in Charlottesville have led to the firing of at least one white nationalist marcher.
Twitter accounts and hashtags are being used to ask the public to identify people who attended that rally. Here with more on this is civil attorney Deanne Arthur. Deanne, good morning.
Good morning.
All right, so let's go back and talk about history here. According to the Civil Rights Act of 1964, employees are legally protected from being fired based on discrimination, race, color, religion, sex, or national origin. So what's the difference in this case?
Well, in this case, it's not about any of those things that the Civil Rights Act actually protects. What people commonly get the misconception is, hey, I have rights, but the Constitution protects from government interference, meaning that at-will employers are free to be able to fire their employees. Now, there are labor laws that prohibit certain things, but I don't think that that will fall under an issue with the labor law.
Well, okay, so the First Amendment prohibits the government from interfering in free speech and religion. So does it protect employees who make statements their employers disagree with from being fired?
It doesn't, unless you're working for a government entity. Most of these cases are dealing with private at-will employers. And employers have an interest and a right to be able to scold, reprimand, and even terminate employees that are acting in behavior that is not becoming of the employer.
Okay, not becoming the employer. There's a lot of gray area there. A lot of that's up to interpretation. I mean, in my contract here with the TV station, I can't go out and embarrass the TV station. And it's under their purview, I think, to define what would be embarrassing to our product, Fox 5.
Exactly.
So how does that play out in the courts?
Well, that's the thing. Each case is handled differently. The courts are actually having to catch up with what's happening in these new areas with social media and other things that sometimes employer handbooks and other court cases haven't allowed for. Right now, I think the best thing for employers to do is make sure that their employee handbooks are airtight, and then they talk about these things and they give them training. Just as you said, here you know what you can and can't do because they have advised you of that. I don't know what has happened with this employee who was fired as far as what is in the handbook, but there's a good chance that there's some type of language that allows for the employer to be able to, like I said, terminate or even scold for behavior that is not becoming. People always have the misconception of it's only what happens while I'm at the employer, but it's actually things that can happen outside of work, especially with social media.
So this person fired as a cook in Berkeley, and we're talking about whether or not he can actually take legal action. Sounds like he can.
He can, but I think that there's an uphill battle. I think it's going to be more about labor laws rather than the Constitution that he should rely on.
Okay, well, so can you get fired no matter what side of the rally that you're on?
Yes, it just depends on what the employer has laid out. Now, the thing that the employer can get in trouble about is what things they have laid out ahead of time. Where it can be discrimination or other types of issues will be if they are allowing some employees, let's say they have an employee that's at the rally that's on one side and they fire the employee that's at the rally on the other side. Then you're running into a discrimination issue that will have an issue that the labor lawyers or the labor laws will have to address, because that would be discrimination.
Well, how about this? Because social media has opened a new door for you, right? And so if you don't go to the rally, but you make public comments on social media, there's a lot of backlash following these pictures, these videos. Can you get in trouble then?
Yes, and it's still kind of a gray area, but it depends. It depends on what you were saying. Sometimes there's people who are what they call inciting violence. If they're doing that by their statements on social media, that is an issue. And even the employer can still terminate them if they are at an at-will employer and they're making comments that would disparage the employer's reputation.
But why though? Because if I'm, John Q. Public, and I work for an insurance agency, the public wouldn't know who I am, and I have a private, say, Twitter account, and I tweet something picking one or the other sides in this case, why would there be any reason that I would get any sort of backlash from my employer, because there's no tie to me and my employer anywhere on my Twitter account?
Well, there's also the misconception of what I'm posting is private. I have a private account, it's only with my friends. That's a huge misconception, because you're actually posting it out to the public and you don't know who your friends are. There was a case where an employee talked about a customer. I think it was Hertz Rent-A-Car. They talked about a customer in a very derogatory way. Right. That customer, a known associate or a friend, happened to be a friend of that person posting. Eventually got back to the employer, excuse me, called the employer, talked about how negative that was, and then the employer felt that Hertz felt that that was negative for the company, and they were able to terminate that employee because of at-will employment.
Boy, new terrain. We started this conversation talking about 1964,
Yeah.
and here we are decades later, and it's a whole different dynamic with social media.
Yeah, the courts are really trying to catch up with social media.
Attorney Deanne Arthur, fascinating conversation. We appreciate you coming in.
Thank you for having me.
All right, the fight between